Good evening, viewers. Today we are honored that we have a special guest with Nazir, a former university lecturer and a senior partner of a law firm, Michael Wosskow. Welcome, Michael, in my show.
Thank you, Mohammed.
And we will start with your early days of life. So you qualified in Sheffield or in any other city?
No, I got my law degree at Oxford in 1969. I then spent 6 months at law school in Liverpool, and then in 1970 I started my training contract in Sheffield, and then I became a qualified solicitor in 1972.
And who was your mentor?
My mentor was a man called Philip Palmer, who was at that time the sole partner in a firm called Russell and Creswick. And when I qualified, in fact, as soon as I qualified, I went into partnership with him, and we remained in partnership until he left Sheffield in the 1980s.
And how you see, because you have practiced since 1960, I will say 70s, you started practice in 70s. So how you see profession?
The profession has changed enormously. When I first qualified, often there would be, say, 2 partners in a firm. One of the partners would deal with what we call non-contentious work, conveyancing, probate, wills and trusts, and the other partner would deal with the contentious work, so that's court work, magistrates' court, divorce court, tribunals, and that's what I did for many, many years really, until I then began specialising in more commercial work. But what's changed now is that firms are much bigger generally, there's been mergers, there's a lot more specialisation. It's harder than it used to be to make a handsome amount of money. It was easier in the 70s and 80s, now it's hard work, but the rewards are still there if you're prepared to work hard.
So when you came to profession, is there anybody who was your ideal, or you have followed somebody?
No, the law has been changed a great deal when I qualified in the early 70s. The divorce law changed. The employment tribunals were started for the first time. So in some ways I was just following a path of my own. The man who I was in partnership with didn't do court work, so I really just got going myself and picked up experience as quickly as I could, yes.
Thank you. And when you started your present practice?
So my present practice was started in 1990, well, it was started in 1989 when I was approached by David Brown, who was then a 39-year-old businessman who was attempting to qualify as a solicitor by doing a law degree at Hallam University as a mature student. And he passed his exams, he entered into a training contract with me. At that time I was aware that he owned the Banners building in Attercliffe, and in 1989, 25 years ago this year, he and I opened a practice in Attercliffe in the Banners building, which was then called Russell and Creswick. And then in 1995, 20 years ago almost, I retired from my practice in town, came up to Attercliffe, worked full-time with David. The firm name then became Wosskow Brown. It was a small practice, a handful of people, and now it's grown and grown, and we occupy a large part of the Banners building.
I've noted that you have quite a few offices.
Yes, we have large offices now. We're expanding all the time. We're going into different aspects of the law, and we're moving forward.
Thank you. And I've noted that in your career that you have 3 years experience of lecturing. So
yes.
How you feel that experience about?
Well, when I came to do my training contract in 1969, trainee solicitors were paid a very low amount. I was paid £5 a week.
I see.
And I started that contract in 1970. And I was then increased to £15 a week, which was still far from a living wage. So I approached the City Polytechnic, which is now Sheffield Hallam University, offered my services to lecture in different aspects of the law. And then in 1970, for the next 3 or 4 years, I lectured in contract law, commercial law and partnership law. I lecture mainly to people who were doing chartered surveyor exams, who were interested in the legal aspects of being a surveyor. And I was able to supplement my income. I made a lot of friends, and also I became expert in those areas of the law that I was lecturing in. So it stood me in good stead.
Thank you. I've also noted that in your experience, you have done a lot of commercial law.
Yes.
So
I changed my path a bit in the 70s and into the 80s and started acting more and more for companies and businesses. Although generally I was still able to act for, say, the directors of the company and do divorce cases for them, tribunal cases, even motoring cases, even fraud cases if it came to that. So while I was doing more commercial work, I was still using the skills that I'd acquired in the 70s, and I was quite well known locally, I think, and I've still continued to act for many local companies ever since. Indeed, I was appointed to the board of a number of companies as a non-executive director to be more hands-on than I was merely as a solicitor, and I've enjoyed a lot of good relationships with local firms.
Because our show is watched by a lot of entrepreneurs, so what is the procedure of setting up a company?
Setting up a company is a very straightforward thing, provided you are prepared to initially pay a modest amount of money. We're talking about hundreds of pounds and not a lot more, to go to a solicitor or an accountant, a chartered accountant. It will cost a few £100. The solicitor will deal with all the paperwork. That means that he will contact Companies House. He will obtain the approval of the name of the company. He will arrange for the articles of association of the company to be prepared. He will arrange for certain statutory requirements to be observed. He'll then present you with a series of books and documents which, as a company, you are required by law to carry out, share dealings, minute book, and he'll ensure that you satisfy all the legal requirements, and then you are up and running as a company.
And how important is this document, as you have mentioned in your conversation, that Articles of Association?
Yes, the Articles of Association are the rules of the company. All companies on first application will get the similar sort of articles to each other. These are printed and are in a recognised form. But as the company develops, it may well be necessary to amend the articles to deal with things like the appointment of new directors, the removal of directors, various aspects of the company where you might want to particularise the articles to suit your need. But it's the one part of the company setup which determines the rules by which the company is run.
So it means it's like a constitution of a company?
Yes, very much so, yes.
And it's important that
very important.
You should take independent advice.
You should be independently advised. You should discuss with your advisor what your requirements are. It may be that there's a number of people who want to set up a company, because initially a lot of people become either a sole trader or a partner. When you get a little bit bigger than that and you want to become a company, there may be 2 or 3 partners, would be shareholders and directors. Then it's absolutely vital that you instruct a firm of lawyers, because in addition to the articles of association, there will need to be a shareholders agreement.
I see.
Which governs the particular things that you want to happen between you as shareholders. For instance, what happens if somebody dies? What happens if somebody's removed from the company because he's been acting against the company's interests? How do you bring in new people? There's a whole host of things that need to be dealt with. Common form of agreement, and again maybe another few £100 to spend, but the total investment of say £1,000, you know that you've got a company properly run, properly prepared for any eventuality, and satisfying all the statutory requirements.
Thank you. Viewers, you are watching Guest with Nazir. If you have any questions, you can email me. My email is shown on your screens. And if you want to join me as a studio guest, if you are a solicitor or a barrister or a chartered accountant or a chartered surveyor, just send us email and your copy of CV, so we will try to contact you. Keep watching SL TV. Michael, now we proceed towards the next part of our show. What are the roles and duties of a director in a company?
Right, the rules and directors of, the rules and duties of a director are laid down in the 2006 Companies Act, which came into force in 2009. There's a number of different duties that directors must follow. They're all common sense, but they say the director must promote the success of the company. He must apply independent judgment when acting in his capacity as a director of the company. He must apply reasonable skill and judgment in making any decisions for the company. He mustn't accept any benefits from third parties. He must not act where there's a conflict of interest between the company and any other transaction. He must disclose to the company any interest that he might have in respect of a contract or a transaction, and just common sense things that enables a director to act always in his very best interest as far as the company is concerned. And if the director is in breach of any of those, the company can sue him. So if you've got a situation where there is 2 or 3, even as low a number as 2 or 3 people, if the company thinks that one of the directors is acting against the best interests of the company, the director can be sued. It's an important position. You have to be very much aware of what you are trying to do and what your duties are.
So it's like, we may say that it's like a role that you are like a guardian
Absolutely.
or a protector of an interest, and you are like a trustee.
Absolutely, and if you're in breach of that, then there can be consequences, yes.
Thank you very much. And when somebody set up a company, obviously the company needs finance, and when somebody goes to a bank or a building society or a financial institution, so a new company will struggle to get finance.
Yes, well, I mean, the reason why most people want to be in limited companies is because it protects you. There's limited liability. It means if the company fails, you may not lose all your assets. The company will lose its assets. And if you were simply a sole trader, you might lose your assets. However, once you have gone into a limited company, it doesn't mean that you can enter into transactions with banks and lenders and finance houses without there being personal obligations, because a bank will not lend money to a limited company without the directors personally guaranteeing the loan. So if a limited company went to a bank and said, we want to develop our company, we need another £100,000 to do that, the bank will say, we're prepared to lend that, but the directors must back that by a guarantee and even by a charge on their own houses. So
what are the limits of these guarantee? And
the limit of the guarantee is something negotiated and agreed between you and the bank, and it's a guarantee will be signed, and in the guarantee there will be a precise amount. It might say £50,000, so if the company has an overdraft and it goes bust, you are liable up to that amount, plus interest that may have accrued since that amount was demanded by the bank. So as a guarantor, you know exactly where you stand, you know what the worst case scenario is, and in 95% of cases it never is a problem, but in the other 5% where the company fails or becomes insolvent, then a guarantee can be called upon by the lender, the bank.
The bank can enforce that guarantee?
Yes.
And anybody can be a guarantor for this? Or
yes, anybody can. Well, you've got to be over 18. It helps if you own property, and that's not necessarily a requirement. And the bank will just make a judgment about whether they want any individuals to be guarantors. But it is a consequence of having a limited company that you may well be called upon to guarantee its liabilities.
And what are the qualifications for a director of a company?
No qualifications at all, as long as you are 18 and not insolvent, or not been declared bankrupt, or not been disqualified as a director, then you can be a director of a company. And that is the way most businesses get going, by becoming limited and then moving forward.
It's a pattern of our show that we ask the rapid-fire questions. So what is your favorite sport?
Football.
Oh, you like, that's good. And your favorite food?
Well, my favourite sport is football. My favourite team is Sheffield Wednesday.
I see.
Who unfortunately haven't enjoyed any real success for 20 odd years, but my 2 sons support Sheffield Wednesday and my 4 grandsons unfortunately now support Sheffield Wednesday, but let's hope that we have some success one day.
And your favourite food?
My favourite food is Thai food from Thailand, a country I visit a lot. I love their food, particularly if I'm in Thailand at the time.
And the best moment of your life?
The best moment of my life was in 1968 when I played football for Oxford University against Cambridge University at Wembley, the famous Wembley Stadium. That was the old Wembley Stadium before the new one was built. I got a blue. That's an award for representing Oxford against Cambridge. We lost 3-1. That really didn't matter. To play at Wembley 2 years after England had won the World Cup was a fantastic experience, and that is one I'll never forget.
So it means England has followed you as a role model?
Yes, absolutely.
Thank you very much. And now we are proceeding towards legal stuff. If somebody wants to buy a share within a company, is it a complicated procedure, and what is involved in it?
It's not complicated. All the shareholders would... there will be provision should have been made either in the articles or in a shareholders agreement that for a new shareholder to be brought into the company, this must be with the consent of all the existing shareholders. So it will be made, again, this is why you need to go to a solicitor to make sure that that provision is incorporated into either the articles or the shareholders agreement. But if a new shareholder wants to come in, let's say he's putting some money into the company, it's a very straightforward procedure whereby the company hold a meeting, a resolution is passed, a share certificate is issued, and the shareholder does not necessarily become a director. That's quite different. There are lots of companies which have shareholders who aren't directors. The shareholder may just be an investor. He may want to impose certain rights on the company as to how much money, for instance, they can spend without him being asked to consent to it. There are all sorts of provisions that go into a shareholders agreement, but in essence, it's a very straightforward thing to do.
Thank you. And any message for our viewers?
The message for the viewers is that if you are setting up in business, immediately you need the advice of a solicitor and or an accountant. You need to make a decision about whether you are to be a sole trader or a limited company, and if you're going to be a limited company, who the shareholders are going to be, who the directors are going to be. And my second bit of advice is to people who are in sole trader businesses or partnerships, if you're growing and you want to expand, you will have to become a limited company, otherwise the bank won't lend money to you. One point that I should have made is that banks prefer to lend money to limited companies because they can get the security of the company's assets, whereas if you lend to a sole trader, it's not so easy to do that. So if you want to expand and you are getting bigger, you will invariably have to become a limited company.
So it means it is beneficial for the businesses.
Very beneficial
to become and join a limited company.
Yes.
Or so it means also it minimizes the risks.
It doesn't. To say it minimises the risks isn't always the case because of the guarantee that I've had to make. The real reason to do it is because you can take the company forward much more easily if it's a limited company rather than a sole trader.
Thank you very much, Michael. This was episode of Guest with Nazir, and I'm sure you have enjoyed it. If you have any questions, please do contact us. My email is shown on your screens, and you can send us emails, and we will try to answer your questions in coming days. Keep watching SL TV. Michael, thank you very much.
Thank you.
Thanks for joining me.
Thank you.